Good morning, good afternoon, and good evening. I am Daun, a research fellow at the CIL. We are pleased to convene a series of webinars on maritime autonomous surface ships and UNCLOS, and I'm very delighted to welcome speakers and audience to the first webinar on Mast and the marine environment today. I have a few housekeeping notes to make before we begin today's webinar. First, the webinar will be recorded only for internal purposes. Second, if you have any questions or comments during the webinar, please use the Q&A function in the menu bar that is located in the bottom of your screen. Without further ado, I would like to introduce Prof. Beckman, the moderator of today's webinar. He is an emeritus professor at NUS Law School and the head of Ocean Law and Policy Program at the CIL. Prof, you have the floor.
Thank you very much, Dawoon, and good afternoon, good evening, and good morning to all the participants wherever you may be. This is the first of at least 3 webinars we plan to have on the Mast or Maritime Autonomous Surface Ships and UNCLOS. It's my pleasure today to welcome at least 3 old friends and hopefully 4. One of our speakers appears to be having some technical problems logging in. But it is my pleasure to welcome at least 3 of us. The purpose of today's seminar is to begin to explore the issues that the autonomous ship might raise for the Law of the Sea conventions. As many of you or all of you might know, the International Maritime Organization is undergoing a scoping exercise looking at the impact of autonomous ships on many of the IMO instruments. The MSC has done a serious amount of work. The legal committee has also reviewed many conventions. I understand FAL is also beginning, but the Marine Environmental Protection Committee has yet to review the environmental conventions. But what we're looking at today is a different issue, and that is to what extent the sort of underlying document, the Law of the Sea Convention, which sets out the rights and obligations of not only flag states, but also coastal states and port states with respect to and is sort of the framework under which many of the IMO conventions come. So to what extent are autonomous vessels going to raise issues with respect to rights and obligations of coastal states, flag states, and port states? And what we're looking at today is primarily the issue of respect to the marine environment. There may be pollution caused by flag states, but then the issues that we'd like to address is what are the implications of the provisions of the convention on coastal states and port states and their rights. We have 4 old friends scheduled. 3 of them are here. All of them have a link at one time to our Center for International Law. I guess in order of seniority, we have Professor Aldo Kirkhope of Dalhousie University, who's one of the clearly leading authorities and one of the very few experts that we can call expert on not only the Law of the Sea Convention, but also on the IMO. So it's a great pleasure that we welcome Aldo back. He's a professor of law and Canadian Research Chair of Maritime Law and Policy at Dalhousie. He's based at the Marine and Environmental Law Institute at the Schoolage School of Law in Dalhousie. Aldo's been with us several times as a consultant, so we're very happy to have him back. Next is, I understand Captain Ashley Roach has joined us. We still don't have his picture, but we'll assume his login problems will be resolved. Ash is another old friend, former State Department attorney, advisor in the Legal Advisor's Office of the U.S. State Department and their Law of the Sea expert, but he also dealt for many years with IMO issues. So again, nobody better to be looking at the combination of issues that we have to address. I should also give a plug for Ash's latest book, the latest issue of Excessive Maritime Claims, is available, I think, in both hardcore and electronic versions. That is always a good read for all of us. So welcome to ASH. I hope you're with us. Next, we have Professor Henrik Ringbaum, another, again, old friend who's visited CIL a couple of times as a consultant. I call him a Scandinavian, but he's actually a Finn who lives and works in Norway. So he has connections to at least two of the Scandinavian countries. Henrik is head of research and Department of Law at the Abo Akademi University in Finland, but he's also a part-time professor at the Scandinavian Institute for Maritime Law at the University of Oslo. Again, Henrik is another one of these people that is the rare ones in the world that are experts, not only, I guess, in private law, maritime law, but also law of the sea. And then our final member of the panel is Dr. Yuri Von Logem, who also spent time when he was doing his PhD at CIL when he was at the Netherlands Institute for Law of the Sea. Yuri is now a senior lecturer at the Institute of International Shipping and Trade Law at Swansea University. Before that, he was a PhD fellow at the Netherlands Institute for Law of the Sea in Utrecht. So it's great to see Yuri again. He probably has less expertise and experience than some of the old guys here, but it'd be interesting to get the views of a young academic who's working primarily at Swansea with people interested in the private law side. Remember, this is a public law seminar. We're not dealing with the international issues that how private lawyers would approach them. So without further ado, we don't have any formal presentations. What I've attempted to do in my email conversations with the panel members was to say, let's assume we're all sitting around a table or around a table at a bar or whatever, and we're raising these issues. And we're going to just interrupt each other and have an informal dialogue. And I thought that I would begin with, I told them I'd begin with a couple of hypotheticals, and then we could get views on how the Law of the Sea Convention provisions might apply and what difficulties there may be. I think in terms of levels of autonomy, I think what we're really worried about here are the higher levels when there's either nobody on board or there's nobody, vessels being controlled by a remote control operator or so on, rather than the first couple of levels in the IMO categorization. But again, let's think about the collision between an autonomous vessel and a product tanker. The territorial sea of coastal state Arcadia, resulting in serious pollution of the marine environment. Yeah, I guess the question would be, what are the rights and obligations of not just the flag state, but the coastal state in this case? And to what extent would the coastal state have difficulties in terms of enforcing the rights that it has under the Law of the Sea Convention in such a scenario? Somebody want to take off? Ash, we haven't had even said hello to you. Can you kind of begin on this? We're very happy you got in with 1 minute to spare.
Well, I had to get the computer warmed up. Let's put it that way. But I'll be happy to begin. But if I do, I'll begin in a very different way than answering your questions. And that is, from my point of view, the Law of the Sea Convention, as I think we all know, particularly on the provisions that are relevant to our discussion, is in many respects based upon the relevant IMO conventions, and incorporates those provisions for the purposes of the LOS convention. But the difficulty with that currently is that the IMO, which has been working sort of on dealing with the issue of Mast vessels in the context of their instruments, and they have done some what they called scoping exercises, both in terms of the Maritime Safety Committee and the Legal Committee. But for reasons that are unclear to me, the Marine Environment Protection Committee has been way behind the curve. But the two that have at least put out scoping exercises also have at least identified what they think are the things which need to be in one way or another modified in those relevant conventions to take into account the various issues associated with autonomous vessels. And as far as I know, they have actually no amendments currently on the table, but I think that would likely be the next step. And for the IMO, it's relatively easy to make those amendments because they have what's called the tacit amendment procedure, something which the IMO, the LOS convention, does not have. And it seems to me it would be inappropriate, let's put it that way, for the parties to the LOS convention to try and figure out what changes need to be made to the relevant portions of the convention, including Part 12, at least in terms of specifics, because I think they would have to wait for the specifics to be sort of come forward in the IMO system, and then they would be able to adapt that. So I don't know that and anything that we would say on this particular issue that you posed, Bob, would necessarily be what it was in the real world when the time comes. Now, granted, if the hypothetical was to occur today, you'd have, I think, a scramble to figure out what the law in that particular instrument might be, but they would be looking to the relevant IMO conventions as well to assign responsibilities and rights. So I'm just not sure where we can go other than to sort of identify these problems and a methodology for dealing with the LOS convention. And I've got some ideas on that, but that's for a little later in our discussion.
Okay, who wants to come in next? Aldo, Henrik?
Sure, I can.
Aldo.
I very much tend to agree with Ash's opening comments that we have to remember that the Law of the Sea Convention essentially is providing a framework for the regulation of international navigation, but it's IMO regulation that constitutes the GIRAs, the generally accepted international rules, standards, and procedures. And the convention is very much relying on those standards. So until we know precisely what the standards for Mast are, it would be interesting to, in a sense, to speculate, but we cannot really be certain how coastal states will exercise their jurisdiction with reference to these GIRAs. But having said that, it seems to me that another preliminary comment that ought to be made here before jumping into the hypo, Bob and everyone, is the role of the flag state. What we have to bear in mind right up front is that the flag state is always the primary jurisdiction responsible for its ships. And Mast will be a ship like other ships that can be registered. So the flag state will have the responsibility to ensure that these vessels are registered and conforming to international standards. So of course, there is a bit of an interim period here. Until we have the adjustment of those standards, specifically for Mast purposes, we will simply have to interpret the existing standards to the extent that we feel that they apply to Mast. So there's going to be a period of transition, if you want. But then Mast will enjoy international navigation rights like all other ships. So coastal states here will have to be wary how they approach the regulation and whether there's any discrimination against this kind of vessel, because they will be vessels that are flagged, they will be entitled to the protection of the flag state, and they will be entitled to exercise international navigation rights. So they will be treated just like other ships. And then, of course, the onus really falls on the flag state, at least as the primary jurisdiction here. They have to figure out how they're going to exercise effective jurisdiction and control. And Bob, I'm really glad that you mentioned right up front that our concern in this webinar is really with the the third and fourth degrees of the IMO categorization of MAS. In other words, ships that are remotely operated and ships that are fully autonomous, because that is where the real problems arise. And especially when you have these different combinations where the flex state is expected to exercise effective jurisdiction and control, and yet the ship may be remotely operated from a totally different jurisdiction. So it raises an interesting question about the ability of the flex state to exercise jurisdiction and control when it doesn't enjoy territorial jurisdiction over the shore office or the shore base from where the ship, the MAS, is being remotely controlled from. And then, of course, autonomy is a problem unto itself when you have full autonomy. So essentially, you have a vessel, no crew on board, and you have an algorithm that is learning from as it goes along, and essentially is making those navigational decisions. And therefore, there is no one on board necessarily to directly communicate, or at least no human person that the shore office can directly communicate with on board. So it will raise challenges for vessel traffic services for sure. And who exactly will vessel traffic services be communicating with? If you have, for instance, traffic separation schemes, and you have traffic services monitoring and need to communicate with the vessels concerned, so you can have those kinds of issues in terms of the extent, the ability of the coastal state to communicate with those that are in charge of the ship. But I would underscore the role of the flex state here. So the flex state is responsible for regulating these ships to a level to ensure that they will be safe. And they will be safe not only for themselves, but also in relation to others that are using the marine environment.
Okay, very good point. I agree with you in many respects. I think we must remember that Law of the Sea Convention was negotiated over a 9-year period from 73 to 82. And of course, MARPL was amended in 73 and then again in 78 during that period. And SOLAS as well in 74. And therefore, what the Law of the Sea Convention contains is many provisions that are intended to incorporate by reference the technical rules that are in the IMO conventions. But the why hypothetical was intended to raise one of the gaps there, and that is that the IMO MARPL, in case of a pollution incident polluting the coastal state, relies, as you rightly point out, primarily on the flag state. But the rights of the coastal state are there. And there's very little in the IMO conventions about the right of the coastal state. But if the coastal state sees that its beaches and its coral reefs are being polluted, it's going to want to take action against the vessel. Now it's going to go out and it's not going to find anybody on the vessel. Now what do? How do they protect their interests? Because as I observe events, often one of the coastal states' quick reactions, particularly if there's been a serious pollution incident, would be to go aboard and probably arrest the master. And that probably gives a little bit greater incentive of the flag state to cooperate, as well as the marine insurers and the owner, etc. Now, you're going aboard a vessel and there's nobody on board, you don't have that leverage anymore. So how do we work? How will the impact be? What will the impact be? Henrik, you want to come in next?
Yes, thank you. Maybe I should take up a little bit of the comments that Aldo made. Clearly, yes, there is a very, very fascinating interaction between the jurisdictional rules of the Law of the Sea Convention and the technical rules of IMO. And I think this is really at the heart of the discussion here today. But I might be a little bit more inclined to take a view that when we look at these provisions of the Law of the Sea Convention, they are, as has been said, they are more recent and much more give much more authority to the coastal states in particular than the MARPOL Convention do, but it's also because it focuses on slightly different things. MARPOL tends to be more on technical and operational discharges, whereas this covers incidents and events. But I think, in particular, when we start looking at these scenarios here, that at the end of the day, we might not be in a need for very many amendments to the jurisdictional regime, because very many of these issues that we are facing will be issues also with existing ships. I mean, for example, the question that Aldo raised on the flag state and the absence of jurisdiction in territorial terms of the operator of the ship, that is a situation today. I mean, no flag state has territorial jurisdiction over the crew of the ship, or I mean, it's quite common that the crew comes from a different jurisdiction, and it's also quite common that the owner resides in a different jurisdiction. So many of these issues are problems or issues that we are already facing, and many others can be resolved by checking the generally accepted rules and standards to the extent that there needs to be that. And I therefore think that UNCLOS has survived very well. It has, and I'm sure that it's going to survive this dramatic change of what ships will be like in the future if it takes place, also without sort of giving rise to a major rehaul of the entire convention. I think it stands stable and provides the most important tools for actually many of the things will end up with really enforcement jurisdiction, and even certain practical issues related to enforcement issues. How do you practically take some enforcement measures if there is no crew on board? And you have mentioned one example on the leverage with the master. I think it would be only a positive thing if enforcement measures would focus more on the ship itself and less on the crew. And I mean, I think we have the main structure there in the Law of the Sea Convention, and I think it's the right thing to do to focus on the IMO conventions now, because I have the feeling that if we can resolve those issues, we are relatively well placed to accommodate Mast.
Okay.
I make a quick comment in relation to something that Henrik mentioned. And Henrik is absolutely right that these vessels are still going to be subject to the gyras that we have today. However, what we have to bear in mind is when you have a remotely controlled vessel from a totally different state, they will be responsible also for complying with gyras. And that's very different from a head office. A head office of a ship or an insurer or whatever, they are not navigating the vessel. The master and the crew are. So they will be subject to gyras, but from a shore office. And that's a major difference, I would suggest, between Mast and the vessels that we have today.
Henrik, you want to come back?
Yeah, just I think this is an example of a practical issue, really, because even for the current ships, you are not normally taking your enforcement measures on a ship on board the ship while the crew is on board the ship. Rather, you wait until the crew has come ashore, and maybe they have even left to another country. And in a way, the problems are very similar in that situation. You have to rely on some sort of agreement with states where they are in, whether it's in the form of extradition or whatever. And for the flag state, this arrangement can be made in advance, of course, just like in the process of safe manning of ship, every single crew member, you can attach conditions to. So flag state does have control of these things and can operate this in advance. The situation is worse for the coastal state, because they may end up with this type of ships and situations without any sort of preparations and possibility to plan ahead of how they want to deal with this enforcement justice.
Well, let's think about that a moment. Assume you have a Norwegian flag vessel, but it is being operated from a remote control operator in one of the Philippines or India. Now, let's assume that the remote control operator is negligent. seriously negligent, went to the restaurant and ship ran aground on someone else's coast. How does Norway ensure that the investigation takes place and the remote control operator is punished, etc.?
In the same way as he would do with the Philippine crew member who has done the same thing on I mean, they are not residing in Norway either. There may be complications, but
if they're on the ship, the flag's law applies. So.
Yes, but what I argue is that the jurisdiction of the flag state is still there. The Norway would still have jurisdiction over these people. The problem is how to enforce it. And that sort of enforcement problem you are faced with in some situations already now.
Actually, I would suggest, in addition to enforcement, how do you get states to cooperate? We already have problems with states not cooperating sufficiently in casualty investigations, and they tend to run their own separate casualty investigation process. Now, in this situation, you will have not only the flag state and the affected coastal state, you might have a third state where you simply have the remotely controlled operation.
That's exactly one of the issues we wanted to bring out, and I'm glad it's brought out so clearly, right? That's Henrik.
If I may explain a little bit of my thinking, I think the chain of responsibility here goes more or less like flag states, and then we have the ship owner or operator, and then we have the crew. That is basically how the international rules are supposed to be put in place. And the new remote operating facility is not very close to the flag state in this hierarchy. Rather, it's close to the crew, maybe somewhat closer to the ship operating company than a regular crew today. But the sort of the chain of responsibility is not dissolved in any way in this development. There is this new entity there, but the basic sort of responsibility structure is still there and might need to be adjusted a little bit. But I don't see this as a fundamentally different thing from the very extra territorial jurisdiction operations that are happening all the time now.
But again, there are cases where, it's coming back to my hypothetical a little bit, there are cases where if the master is clearly negligent and there's a collision or a grounding and he causes serious pollution, the coastal state can take action against the master, right? Now they still have to release if the flag, depending on how the flag state replies, whatever. But in this case, there may be cases where there's nobody on board and there's nobody to arrest. So how does the flag state protect its interests?
I think in this particular case, if you ask me, this would be a typical case where the Mast would lose its right of innocent passage. In particular, if it loses its passage in the context with its collision, etc. This gives in the coastal state very broad possibilities to exercise their enforcement jurisdiction over the ship, independent of whether there are people on board or not. And then, of course, they might, or they will have to find somebody else to talk to about the ship's whereabouts. But the jurisdiction is there to actually detain it and arrest it. And I mean, really with quite heavy measures if needed, and heavy measures, I believe, work on unmanned ships as well as a means of detaining the ship for further investigation. And then you focus on the ship itself. I think it's been an unfortunate habit in the practice of pollution incidents that you sort of focus too much on the human beings on board, and this way, I mean, then you use the ship as the leverage, and this is in a way what the private law of arrest is based on, and I think this would be a solution that would be fully workable.
You know, another solution would be for a flag state, or for flag states generally, to require that Mast vessels that are registered under their flags are registered on the basis of remote controlled operations undertaken from the flag state. That would solve the problem.
From Marshall Islands.
Maybe they shouldn't be in a position of registering mass if they're unable to exercise jurisdiction and control over the remote operation.
But in that context, the flag state has the possibility to agree with the country of the remote center, if it's somewhere else, about how they deal with these things in advance. So that is, I mean, extradition is just one example of how things can be settled. But I think the coastal state does not have that luxury to prepare it ahead.
So
yeah, otherwise, the problem that we face is, fine, we have clear rules for coastal states, clear rules for flag state, clear rules for port states in terms of how they exercise jurisdiction, but not the remote operations state. And last thing we want in the law of the sea is to have a fourth category of a state there. So what would be important here is to ensure that there is ability for the flag state to exercise effective jurisdiction and control, right?
Yes.
That is what it boils down to. And you may be right, Henrik, maybe through agreements, but maybe there is a role then for the IMO to develop a framework so that there is a multilateral arrangement
Absolutely.
to ensure that flag states are able to exercise this sort of jurisdiction.
okay, Yuri, do you have any comments or questions even?
Well, I think I approach it more generally because, like that, we probably already went into the very nitty-gritty. And as you mentioned at the beginning, I'm not as well rehearsed as some of the other speakers on the panel. But when I think about the introduction of Mast and the Law of the Sea Convention, I do have a slightly different view, in the sense that I do perceive it more as a paradigm shift, in the sense that if you, in my view, interpret a treaty or a treaty provision, we do have the text as it is. And I think some of these issues are swept under the carpet, because if you analyze the Law of the Sea Convention and its provisions, we all tend to agree that they are written with a view to them being manned. So I'm always wondering to what extent the IMO conventions would be able to completely resolve these issues. And my answer would be that they probably are not able to do that. And I think it's also important to keep the distinction between whether we're talking about fully automated vessels, in relation to which I think the Law of the Sea Convention raises very significant difficulties compared to those that have an offshore operator. And the tendency seems to be that a lot of people seem to accept you can have a master, or that the master role would now be somebody on shore, with which I do have some difficulties, for example, because if you look at the function of the master currently, he's present on board and he's the singular master. If you look at the text of the Law of the Sea Convention, Article 94, it makes mention of a singular master. How do you replicate that situation on shore? Are you going to have one person behind the computer screen monitoring that ship for 24 hours? I think from the view of labor standards, that would not even be feasible. So like, that's why I'm a bit more sometimes hesitant, because it sometimes argued, of course, a flag state has autonomy to register a ship. And in the literature, there seems to be the argument that once a ship is registered, the coastal state has to accept it as a ship. But to me, that seems to be a bit of an easy conclusion, because I would say flag states are only allowed to register a ship as a ship if they would be able to comply with the international regulations and standards. And I think that currently is certainly not the case, because you have many gaps. And so if they would be introduced today, I would say the coastal state can say they don't even have a right of instant passage, because they would not be able to comply with the IMO conventions as they stand currently. So in my view, more needs to be somehow done to, particularly, of course, amending the Law of the Sea Convention itself is going to be an exercise you don't want to go through, because it's not going to be to have any sort of positive result. But you could perhaps, though I do recognize the same difficulties in a very multilateral approach, you could look at a clarifying annex, which is feasible, but it has been problematic in the past as well. But in my view, we have provisions in the Law of the Sea Convention, and based on a textual interpretation, and my interpretation of the rules on treaty interpretation is that we primarily look at the text, we look at the context, but there seems to be a tendency to very much have a theological approach to treaty interpretation, which I would think is a bit more problematic. And that is one of the arguments, at least in my view, why if you focus exclusively on the IMO conventions and fill any gaps that arise in that context, there will still be remaining gaps. So I think the point Aldo mentioned about flag states, because the issues you raised about problems for the coastal state or the port state, they seem to be mostly practical in nature. And if I think about it more generally, I think the role of the flag state becomes more important when it comes to masts, even more important than it is currently in relation to manned ships, because coastal state, port states become very reliant on the participation of the flag state. The example you mentioned about a master or an offshore controller being located nearby or in a different territory, how can the flag state effectively enforce in that example? So in my view, there are many issues which are in the Law of the Sea Convention itself. And of course, it is a framework convention. It was meant to be more generic, but I don't think you can completely sweep the text under the carpet by saying, okay, yeah, we can deal with all these issues through the IMO conventions. To a large extent, you may be able to do that. But I think still the issue if you have a flag state, and I think, for example, a number of flag states have indicated that they won't register autonomous vessels. I think, for example, Malta. So what if a autonomous vessel would go through the territorial sea of Malta? Will it actually accept that vessel or that vehicle or craft being a vessel? And I don't think they currently, as the international framework stands currently, they would not have to accept that, I would say. So I think I tend to agree, okay, are they ships? Sure, we look at the autonomy of the flag state, but even then, you still have that very important point, which Aldo also mentioned about, is the flag state able to effectively exercise control and jurisdiction over these vessels? And I think currently, if nothing is being done more specifically, my answer would be that they can't, in many circumstances, comply with that flag state obligation, that they more or less would breach international law automatically by registering such a vessel. So I think also we probably need to rethink about, okay, what is meant by general link? And of course, it has been construed as being about effectively exercising jurisdiction and control in the case law. But here, I would say, given that the example you mentioned about arresting or for the port state, it has more limited options to pressure the flag state into acting or complying. I think indeed, what Aldo mentioned is very important, that the flag state should be more critical about whether it actually is going to register autonomous vessels, because it seems to have more extensive obligations in that regard.
Okay, thank you. I think we're coming back to that issue of how do you effectively exercise control when you have a remote control operator that is in charge of the vessel. And to me, it doesn't make that much difference whether it's a UK flag and the guy's sitting in London or a UK flag and he's sitting in India. Are you effectively exercising control over that vessel when you're allowing a remote control operator in a computerized system on board the vessel to be in charge of it? We're coming back to that also. There's no definition of ship or vessel. The terms are used interchangeably in the Law of the Sea Convention. Neither is defined. Some writers say, well, every state has the right to register a vessel and every other state must accept that. I'm not so sure of that. You might find that you're registering something as a vessel which other states won't recognize as a ship. Could we move to some of the questions? I could read out some of the questions that are coming in. One is, could you comment, maybe we've covered this in part, but could you comment on what would be the implication of the IMO regulatory scoping exercise to the Law of the Sea Convention. I mean, we've generally covered that, but it is a question again. I'll take a stab quickly. There are a lot of provisions in the convention which we say incorporate by reference in the Law of the Sea Convention, which incorporate by reference the rules and regulations in the IMO conventions, whether it be SOLAS or STCW or so on. The question is to what extent there are Law of the Sea provisions which simply saying, well, this incorporates by reference the IMO. There may be some gaps. In the IMO scoping exercise, they're looking at their own conventions. They're not looking at the Law of the Sea Convention. Aldo?
Yeah, I think that's an excellent question that has been asked from the participant. Because let's face it, the IMO can develop and scale up the gyras applicable to mass. But frankly, they cannot go about interpreting what is the responsibility of the flag state in terms of how it exercises jurisdiction. They can only say, look, a ship must have this equipment, it must operate to this certain standard, but they're not going to tell the flag state how to go about implementing and enforcing that. So they have to stop somewhere. Sure, the IMO always provides guidance on how to implement conventions and so on. And it'll be interesting to see how the IMO will do it when you have the possibility of remote operations from another jurisdiction. How far they can go before they cross the threshold into what is an interpretation of the responsibilities of the flag state. That is where they might have to say, look, we are not empowered to interpret UNCLOS here, so we might have to draw a line somewhere. Or, as they have in the past, they might seek the assistance of the Division for Ocean Affairs and the Law of the Sea in the UN Secretariat for an opinion.
Okay, that's let's not move to that topic yet. Any other comments on that question? Ash, you're thinking.
The provisions on the responsibilities of the flag state are uniquely set out in Article 94 of the convention, and is not based on what exists in IMO conventions. So the task in due course is going to be for somehow to figure out how to clarify the provisions of Article 94 for the purposes of Mast ships.
May I just fill in that from there, Ash, that there is a link between the IMO Convention and Article 94, because the critical paragraphs in Article 4 that are usually referred to are the number 3 and 4. And then we have number 5, which says that for whatever purposes discussed above in paragraphs 3 and 4, reference shall be made to generally accepted international rules and standards adopted by the IMO. So I think it would be a completely bizarre situation if we would have a convention that was adopted in the 70s that would sort of blankly rule out a development that the International Maritime Organization would be willing to endorse and support and regulate, just because it's obvious that this type of issues were not even in the head of the drafters of the UNCLOS. And the whole point of that convention was to establish a kind of a framework for how things are done and who is doing what and what organizations are responsible for what. And in shipping, it was very much centralized into the IMO, which also gives the IMO a significant freedom to operate in this. And I would say, in particular, in the case of Article 94, when there is this direct reference to 5. But I think the question of the coastal state is you referred to it, Yuri. It's true that in this particular example, maybe the more interesting question is, can this kind of ship be there in the first place, rather than the collision, the post-collision sort of cleanup things? Does it have the right of innocent passage? And that is not clear, but that doesn't, in my view, depend on the definition of the ship, because I think it would be equally bizarre to have an interpretation saying that these cannot be ships under UNCLOS if the IMO, if they can be under all IMO conventions. But in fact, there are rules allowing coastal states to in the territorial sea to require all ships to meet the international standards, which includes the watchkeeping provision, which include a rule that there has to be a physical person on the bridge, for example. I mean, this can be a real problem, maybe not to the extent of loss of innocent passage, but they raise very interesting questions on the interrelationship between them. But this more fundamental question that Bob is raising about the facts, I think it would be a very awkward situation in view of the nature of UNCLOS if we would say that this convention has to be amended before we can proceed in with the Mast.
Well, we must keep in mind that amending the law of the Sea Convention is a bit like going to the Mars. As we're seeing now with the BB&J discussions. So what we're talking about, and the whole reason why you have 94 and the other provisions that incorporate the IMO conventions by reference, is that you know that standards are going to change, technology is going to change, and therefore you're leaving it to the IMO to develop the technical rules, and they're automatically incorporated by reference into the general provisions in UNCLOS. But when they drafted that, they didn't anticipate autonomous vessels. The assumption was there was a master and a crew aboard the ship. Now, again, ship is not defined in the convention. Warship is, but generally ship is not. So again, we're struck when several IMO conventions have their own definition of ship. But the question then becomes, well, can the IMO develop rules which we could incorporate by reference into, and it would solve most of the problems of the UNCLOS general provisions? I have a couple more questions I'd like to bring out. For enforcement, might the IMO require the owner-operator of a mast to post a bond of a suitable size, perhaps on a voyage basis, that would be held by a third party? So that there's pollution of a coastal state, at least there's money up front. I
would think the IMO certainly can do that, but they'd have to do it through appropriate amendments to one or more of their instruments. And I don't think that right now the scoping exercises have gone that far.
No, so I understand it's scoping exercises. They're looking at the existing provisions to say to what extent these have to be. They're not looking at what new provisions might be required, as best that I know. Again, I haven't followed it that closely.
But if we are talking about pollution, in a way, there is already a mechanism like that, because we have the civil liability conventions which are designed to cover all the pollution costs or damage that is caused by ships, and that is also linked to a compulsory insurance certificate that needs to be brought on the ship always, so that I mean, for this covers bunker fuel oil, and this covers oil carried in tankers for the moment, but for those ships there is a kind of a security that would apply to mass ships as well, although I think everybody agrees that oil tankers are not among the first ships likely to be mass operations.
No, you might have a mast, but you might have a mast running into a tanker that causes another issue.
Yeah, but this would then cover the third party damages anyway, because of the strict liability of this convention.
And one should look at the results of the scoping exercises by the legal committee to see whether or not they've addressed this particular issue on those conventions.
I think one of the questions that they've raised is clearly one needs to understand what some of the terms in the convention will be referring to. Like we have some conventions that refer, for instance, to the operator of a ship. Does that mean also a remote operator of a ship?
Okay, good. Question to Aldo. Does it mean that there is to be an international controlling organ checking on the capacity of states? I assume that means you know what he's referring to.
Yeah. Bob, I noticed that
Capacity
Yuri
of
was
states
trying to
to-
attract your attention first. I don't know if you noticed that.
Sorry, go ahead.
I was just wondering about, okay, because the previous question about could they ask for a bot? I'm also wondering whether a coastal state or port state could not set that as a condition for entry. I think we're perhaps also overlooking that aspect in terms of port states. When it comes to vessels entering their ports generally, they could set potentially such entrance requirements. So I'm also wondering about, okay, is it also not a matter, what I pointed out earlier, I'm not sure to what extent the IMO would be able to completely resolve it, but also that port states in that regard have some role to play, that you also think about entry conditions for mass generally that could be set by the port state or the coastal state.
Yes, I would agree that if the mass is actually entering the port, if we're talking about port states, that is clearly an option for port states.
Yeah, port states can deny entry.
Yes, to mass. They might decide that we don't want to have anything to do with this sort of ships, and they are in their full rights to do that. But even without that, of course, you could argue that if you arrive at a situation in a port state where a mass is held for some pollution events before, and there is this release of vessels, the whole safeguard part of law of the sea convention, which also deals with this reasonable security in the form of a bond as a condition for releasing the ship, and so there are many possibilities in there.
Good. Any other comments or reply to?
I can answer the question that was raised earlier. I didn't want to avoid that question. I think it's important to clarify that the IMO is not a controlling organization. The IMO is not an enforcement agency at all. The IMO is really a forum. IMO, in fact, is described in its own constitutive instrument as a machinery for cooperation, basically through its various committees, subcommittees, and so on. So if there are going to be greater controls over mass, they can only be developed through GIRAs, through generally accepted international rules and standards, new GIRAs for this vessel, through the international conventions. And then state parties themselves will be responsible for implementing and enforcing these GIRAs, not the IMO.
Okay, any other questions, comments following up? I've got a longer question here. Let me read it. We are seeing mass operators building and operating increased number of larger vessels, more than 50 meters in length, albeit for specialist ship operations. How much of what is being discussed will be ultimately be derived by customary practice and case law, especially as the IMO is likely to take at least 8 to 10 years before permanent regulations are likely to be in place? Anybody want to comment on that? Henrik?
Yes, thank you. That's also a very interesting question. And I think, well, first of all, it is not like in certain other fields of regulating mass. When it comes to these technical and safety standards, they of course have to be somehow agreed ex ante, because unless you pave the way for operating mass in these conventions, it will be very difficult to have the possibility to operate them in the first place. But it's true that to do it in a foolproof manner or in a very prudent way will take very, very long time. And the question then is, what are there some sort of interim things that could be done? And there I think we have seen a very interesting development in the IMO in the past couple of years with the adoption of the interim guidelines on mass, which is not a convention amendment, and maybe it wasn't even intended to affect any standard setting or things like this, but they open up for, at least they represent some sort of endorsement by the IMO for doing trials with mass in waters which are not defined, which could be high seas or international trade or something. And they are not strictly requiring compliance with all the rules. So this could be one example of how things would work in the interim until you have a solid legal framework, that you would somehow use soft law tools, and you would maybe even try to accommodate in the GIRAS notion and you this type of things. And I think this is far more interesting than maybe the IMO itself realized when adopted these guidelines, because they open up for various interpretations in this regard.
I suppose one could also add to that, Henrik, that it's not that MAS are coming into a regulatory vacuum. The reality is we have regulations that already apply to all ships. So it's a matter perhaps of interpretation. And where there are specific issues, flag states under some of the conventions, especially when we're dealing with experimental ship, can actually issue temporary exemptions from specific rules to enable a particular vessel to operate, and then to see what we can learn from that before it's fully regulated.
Yes, but sometimes those regulations, or normally those exemptions, are really for highly technical standards like the low lights or equivalence rules in SOLAS chapter 1 to 3 and this type of thing. When it comes to collision regulations or this, we don't have the similar flexibility for flag state to have this. So there are differences between the IMO rules in this regard as well.
Yeah. Elsewhere, in a piece that I wrote at an early stage when I was looking at MAS, I suggested that perhaps what we might need in relation to MAS, especially for navigation at night, is specific lights that demonstrate that the vessel is MAS. As you know, for collision avoidance regulations, all ships are to carry certain signage for daylight operations, and then lights for nighttime operations. And for other vessels in the vicinity to be aware that there is a MAS vessel, that there is no one on board, basically might be a way through a system of lights.
This might be acceptable and probably needed, as long as you don't propose that this light shall always go along, also go along with some additional rights for the ship, because that, I think, is a foolish way to walk, to somehow make the other ships stay clear of the MAS and treat it like some sort of vessel with restricted maneuvering capacity. Or so. Yeah. No,
it's a difficult one, Henrik, because Colregs do rely on a certain category of vessels as privileged vessels, as stand-on vessels. But the reality is that the rules on stand-on and give-way vessels in the collision avoidance regulations are also premised on there being human control on board that can decide on the proper action to take to avoid a close encounters situation. And the reality with MAS is if you don't have anyone on board with category 4 vessels, as it were, then there is no one that will be able to take that preventive action. And should you then have the collision avoidance regulations rely totally on an algorithm to determine what avoidance action the MAS vessel should take?
Yes, this is a very important question, and also on how can you ex ante sort of define all those vague provisions in the Colregs, which are there and vague precisely because they need to be vague, because they need to sort of be applied ex post with a number of different type of factual situations. And so it's a very tricky question on whether that actually can be sort of quantified to the extent that somebody can say that we have a Colregs compliant algorithm here in this little chip. I have my doubts on that, but it's an interesting question, but maybe brings us a bit far away from the test cases we have.
Let me ask one more question coming from the audience. Required territorial nexus between the flag state and the remote operations center might be the best in an ideal world, but in practice, wouldn't this face strong resistance given that it would revive the genuine link and perhaps discriminatory effect in practice by reducing flag states to those with the capacity to develop the necessary technology in remote centers? Back to genuine link problem. Anybody want to respond to that one?
Yeah, as I said earlier, I see that that is a potential problem. But that's why I suggested that if flag states would, as a requirement for registering mass under their ships, require that remote operations take place in the flag state, that would enhance, of course, the genuine link argument.
Okay, anybody else want to comment on that? Yuri.
Yes, no, I would fully agree with Aldo's point about that the flag state should indeed perhaps legislate by saying that these control centers need to be in their territory, but you do indeed have the question of to what extent would flag states, particularly some flags of convenience, be willing to go along those lines. I think to a certain extent, we have a reformulation of problems that we already have with flag state jurisdiction in the context of flags of convenience, which probably arguably become more pronounced with Mast as well. So I think it's a very, indeed, if you talk about genuine link, the way how it is construed by the one raising the question, that would make a lot of sense. But I'm just wondering about, okay, if you look at the track record of some flag states, where they would really be willing to look more closely at enhancing this genuine link. I'm just wondering whether in practical terms, they would be willing to do that. And I think also the question refers to creating a level playing field, which would probably be another consideration as well. But I'm also wondering about, okay, to what extent are flag states willing to look at that more closely by enhancing the general link in that particular fashion?
The other thing that we have to keep in mind too is that we now have two advisory opinions that have clarified a fair bit what due diligence of a flag state or a registering states in the case of seabed mining states actually amounts to. And perhaps flag states here will have to be very careful about mass to see the extent to which they are potentially opening up claims to responsibility and liability in terms of situations where they have not exercised effective jurisdiction and control that would have prevented a casualty.
Okay, good. Any other comment on that? Otherwise, another question coming in is, in the case of a vessel operated by a fully autonomous AI, what kinds of standards and regulations can the flag state really impose other than requiring human oversight, human in the loop?
I think this is a very interesting question as well, and I think this has been neglected so far in the entire work of the IMO, which is sort of backward looking. It is looking only at what sort of rules of the existing rules that have been developed for a different purpose need to be amended or adjusted. The real challenge, in my view, is to ask and consider what new rules will be needed to accommodate this new type of ships. And there we need a number of things. I mean, irrespective of we are talking about reducing manning on board or increasing automation, we would need to have some sort of lookout function. Clearly, there is a need for standards for that. What does the machine has to be able to observe? What are the minimum criteria? This type of route. Another one has to do with what we already talked about, the navigation decisions. It may be easy enough to create a machine that makes sure that the ship never comes close to another ship or shore, and therefore the call regs don't sort of materialize. But what requirements do we put on these more sophisticated navigation computing systems, algorithms? There needs to be some standard in that area too, I believe, because, and they might well be, or they have to be probably goal-based, and they have to be flexible and sort of functional in nature. But before we can say that this issue is settled, I think changing the existing rules is just 15% of the big problem we have in front of us, and fixing the gaps is the remaining 85%.
Okay. I have one more question coming in. What is your opinion maybe is to develop international regulations such as the new COC, I don't think Code of Conduct, under STCW, focusing on ship wireless operators to coordinate mass? We handle the remote operators through STCW. Possible?
This is an interesting question, and also points to another thing that both MSC and the LEDGE committee have made it very clear. They said, we don't really address some of the labor, or rather the labor. There might be some training aspects that the review of the conventions will be able to address effectively, but not all labor aspects. In fact, they seem to suggest that perhaps the ILO itself might need to take a hard look at the Maritime Labor Convention as well. And I believe Yuri made a point earlier concerning conditions of work. But moving that piece aside, the maritime labor side, STCW essentially concerns seafarers. So one will have to think in terms of how to characterize the shore-based operation. If these persons are given the status of seafarers, and whether characterizing the person in charge of the operation as the master, the onshore master, whether you have an officer on watch, to relieve the master, as it were, or to have an alternative masters to avoid the problem that Yuri identified earlier, the 720, the 24/7 kind of scenario. But these persons will need some sort of a legal status, and they will need certain training requirements, whatever they are. So can we assume that somebody who's had experience at sea will be sufficient to step into the shoes of the shore operator? I think we still have to determine that. And I think the current discussions seem to suggest that we should have at least some experience at sea for these people that might be working at this office. But it's going to be a very interesting question. Should STCW, the definition of seafarer, be extended to include remote operators? And then what sort of standards should be extrapolated from the current STCW to apply to somebody who's operating the vessel remotely rather than being on board? I think that's an open question at this stage. Wouldn't you say, Henrik?
Yes, absolutely. And my own view on that is that until we have that new legal framework for remote operating, because they may need a different educational profile as well, in addition to the seafaring elements. But until we are there, we should apply the STCW analogously to those people, because that's the only tool we have. If we sort of leave it up to every single state to determine what qualifications and requirements are for the, then we are in a very dangerous situation, I think.
Okay, another question for Professor Cherkov. Are you suggesting that Mast might not be as safe as ships with crew on board?
No, not at all. Rather, my concern is more as a lawyer, the extent to which in the transitional period until we have full Mast dedicated regulations under the IMO, the extent to which we can, as Eric pointed out, analogously apply the existing legal regime to address the perceived legal issues that we're dealing with.
Good. I have a more law of the sea question here, probably. Broadly speaking, is the understanding correct that Article 94 of UNCLOS should be interpreted taking into account Article 58.2 and is therefore applicable to ships in the EEZ? I think Article 94 is applicable to ships wherever they may be. Isn't that correct, right? So that's I think the answer to that one. Next question is, what happens when all ships are mass? Been a long time for that one, but
things will be much easier then when it comes to communicating between ships, etc.
Yeah. Well, it means that there might never be an issue of safety of life at sea because there's no life working at sea. But that is a very unrealistic scenario, because the reality is that we will always have multiple users of the oceans. We will always have fisher folk on the oceans. We will have other ocean users. So I think it will be very, very unrealistic to think that, even if we were to think of commercial vessels alone, for those to be totally Mast.
At the latest, at that point, the idea that Mast should have certain navigational privileges would be dead when all single ships are Mast.
Yeah, I guess the question again from point of view of coastal states, could they require that Mast mandatory ship report, or that Mast take particular sea lanes when exercising innocent passage, etc.? That might be a way in which they don't have the technology. They want to say, well, you can pass through our waters, but you must take a particular sea lane through, or you must call in. Who would call in for mandatory ship reporting on a Mast?
Well, this will raise another interesting question for the IMO, and I'm not sure if this particular issue has been raised as yet. You see, under Colrex Regulation 10, there's the rule on traffic separation schemes. And of course, the IMO is the organization that is really mandated to designate routing measures. And they do so on the basis of requests from states. But if there are requests from states where there are some potential technological concerns or inability to service a local traffic separation scheme, then there might be some interesting questions here, the extent to which Mast can operate safely if there isn't a traffic separation scheme that is managed properly. It's a consideration for the IMO in designating these as routing measures.
But the general tenure of coastal state rights over ships, foreign ships in the territorial sea, is of course that you can put various navigational requirements on them, and you can even temporarily suspend the right of innocent passage. But what you cannot do is that in reality sort of prevent them from moving. And you can see it from the nuclear article, I don't know if it's 23 or whatever, that the perceived increased safety risk of a ship does give some additional tools in this regard, but it doesn't give you the right to prevent those ships from moving altogether. So I think this is an analogy maybe that could be relevant for Mast as well. But then of course we have this question that I referred to earlier, that you can actually require all ships to follow international rules. And as long as there are no international rules permitting ship operators to remove their watchkeeping officers, then you have a problem as a Mast in the territorial sea. But there is a discrepancy between the prescriptive jurisdiction of the states and its right to take measures. So it doesn't necessarily mean that the ship loses its right of innocent passage, even if the coastal state has the right to demand certain things. So this is one of the interesting areas of the Law of the Sea Convention that will be very relevant when it comes to Mast, I think.
But under Article 21 on innocent passage, the coastal state laws cannot apply to design, construction, manning, or equipment. So very little they can do. They can't pass laws that prohibit Mast from passing through their territorial sea. That's to be a manning issue, right?
Unless conforming to international standards.
Yes.
Yes, and as long as the STCW, for example, is not amended, it would mean that they can require Mast to comply with, but not. I mean, it works in a rather different way than in a normal pollution context here. It is they can require that the ship complies with all but the absence of international standards, which is the relevant thing in this case. What is the significance of that? Does it mean that it cannot put any requirements on those fields that are not regulated at all? I would say yes, but
okay.
But this is formulated in the form of sort of a maximum requirement. But in this case, we are talking about a gap in regulation rather than a certain standard.
Okay, there's another question on whether Masts have the right of innocent passage. I'd say on a general reading, all ships have a right of innocent passage. So Mast would as well. Anybody disagree with that?
I think it would be a logical conclusion if you say it is a ship or a vessel, then all the rights and freedoms attached to that vessel as well. That's why I brought it at the beginning, some hesitancy. I do see the problem, and Henrik alluded to that as well. If you're going to say, okay, under the Law of the Sea Convention, Mast would not be a vessel, then you have all these IMO conventions which do see them as a vessel. But like I said, the difficulty I always have, if you look at the Law of the Sea Convention, it does seem to presuppose that vessels have to be manned. But like I said, if you come to the conclusion they are ships, vessels, I think you can't really conclude differently by saying that they would have a right of innocent passage generally. Perhaps you can limit the right of passage to a certain extent by saying, okay, the point Henrik made about as long as we don't have specific regulation, Masts are acting contrary to the current international laws and regulations. So that would be a basis for the coastal state to act upon. But therefore, I think it is a very much a threshold question about, are they ships? And if you come to the conclusion that they are, then all the other rights and freedoms do attach to them. So I think there's not so much a question around that once you actually say they are ship vessels, as most people tend to conclude.
Yeah, in addition to the rights, of course, they have duties. So they will have to respect the laws and regulations of the coastal state, regulating innocent passage in accordance with the convention. So if Henrik's scenario in this transitional situation, until we have dedicated gyras for Mast, a coastal state might say, look, sorry, only vessels that are crewed can actually navigate through my territorial sea. They may well be entitled to enforce that.
But not necessarily to the extent that the right of innocent passage of the ship is sort of affected, because rights to legislate doesn't necessarily mean right to interrupt innocent passage.
Yes, I have a question relating to how does a Mast vessel communicate with the shore-based personnel in a coastal state? Assuming the coastal state thinks that it might be involved in passage which is not innocent, it's doing a ship-to-ship transfer or something. It's engaged in some activity which would, but normally you would then contact the master and request information. How do you do that with a Mast? Who do you contact?
I think nobody, even the most advanced thinking technocrats, are foreseeing ships that would operate without any type of human involvement at all. I think at the very latest, as an alarm goes or something, even in a fully automated vessel, there would be a person who would respond, pick up the phone, basically. And I think technically it's an easy thing to sort of just redirect communications to a shore-based station from a ship. And I think if this is indeed the main problem, this could be a requirement that there has to be a person who is available for this. And it might be a very reasonable thing to require from us, that at the very least, when the coastal authorities have a problem, that there has to be somebody at the end of the line.
Okay, I'd agree. I'd say mandatory ship reporting probably could be a requirement as well, so that whenever anybody has a system in place, you call in the port to let them know you are passing through, etc. Again, who's calling through, whether they're sitting in a remote control center or whether they're sitting in the flag state, so long as somebody's communicating with the shore-based facilities in the countries they're passing through. How do you envisage another question coming up? Any legal issue affecting activities of a Mast that would make the passage not innocent? Transshipment between a feeder vessel, a ship-to-ship transfer of illicit goods, whatever makes the passage not innocent. How do you deal with that with a Mast? remote control operator could stop the vessel to transfer contraband to another vessel. Now what? How does the coastal state deal with such an issue?
Well, coastal states deal with ships without crew on board regularly in salvage situations or in, I mean, and I suppose that many Mast constructors would have a self-interest in putting some early, easily accessible points on the ship that you could actually tow a line to and bring them from, I mean, attach them to a tugboat or whatever. I suppose this type of solution would be needed for this, but it's, again, I see it more like a practical issue of how to exercise the enforcement than a particular legal problem.
You know, there could be theoretically a situation where a Mast vessel exercising innocent passage might be in violation of innocent passage if it's, for instance, as part of its operation through its sensors is collecting data, scientific data, as it is transiting. That is arguably not innocent passage.
Yes.
No, quite clear, not innocent. It's in Article 19, I think. The question then is, how do you arrest a vessel that you has nobody aboard that you believe is violating the right of innocent passage?
I think it's quite scary to look into a cannon pipe, even if you are a remote controller. If I express myself bluntly, I mean, force works on Mast as well, I suppose, if it really comes to that bad situation.
Well, you know, wasn't this, Ash, you might recall in the deliberations of SUA and the protocol in particular, the potential weaponization of a ship was considered a potential threat, right? So
yes, but again, in the SUA context, was all premised on the basis that they were manned ships, and that becomes the question of whether or not SUA even should apply to Mast, and if so, certainly how do you do it legally?
Okay, we have a couple other questions. To what extent a VTS operator from the coastal state could legally take control of a mast?
Well, legally take control, I'm not sure if that is the right language to use here, but they would certainly have the authority under normal operations to direct the vessel, in the sense to issue directions for its navigation. If it constitutes a safety concern, for instance, if it's in the vicinity of a port, you name it, it could be given navigational instructions.
Well, again, that's a question of how the mast would react. Assuming they're in the traffic separation scheme in the Strait of Malacca and Singapore, and for whatever reason, the coordinates are wrong or the programming was wrong and they're going into the wrong lane, how does the VTS operator contact them and how do they adjust their route, right? Mm-hmm. When you have lanes that are...
to Henrik's point, right? I think we have to be realistic here to think in terms of the development of this technology can reasonably be expected to involve the ability of even somebody who's remotely located to communicate on behalf of the vessel or to be contacted with respect to the vessel. I don't think we're looking here at technologies that are impossible to communicate with. At least I haven't seen that technological scenario as yet.
I guess the question would be, is the technology to the point that the remote control operator could give a warning or direction, and the VTS operator and the remote control operator in the flag state would actually be able to adjust the vessel in time, make the necessary adjustments, change direction, etc. That'd have to be quite sophisticated with almost instant communications.
And of course,
yeah.
there will always be problems with instant communications, and this is why one shouldn't place too much sort of independent faith in this remote operation, because there will always be lags in and even if we think of that this is a much easier in a way scenario to deal with many of the legal problems, in practice I think even these remotely operated ships needs to have a certain degree of autonomy on how to deal with the situation where the communication breaks, and they need to be, for those purposes, they need to be autonomous and be able to behave by themselves, and there needs to be some sort of common standards for how that happens. An interesting thing, speaking about VTS, is also what we are talking about up here in Finland for the moment, pretty much is remote pilotage, which is kind of a cousin to the VTS, but focused on one single ship. And there, of course, there has to be an agreement, a prior agreement between the ship and the pilot who is on shore then and instructs or guides the ship. But it's a kind of a middle situation between traditional pilotage and VTS, and it raises very interesting questions on liability, for example. But
maybe, Henrik, it also raises an interesting analogy to consider here in remote operations, because you know, in pilotage law, the pilot never has command of a vessel. The pilot only has conduct of a vessel, and it's based on issuing recommendations, essentially, to the master or the officer on watch to navigate the vessel. And maybe we might be seeing that kind of scenario as well, having conduct rather than command.
So who's in command? There's no there's no master.
The shore-based operation presumably will have somebody who will be responsible for the safety of the vessel in terms of the decisions to be made. That will be the person who plays the analogous role to the master, right? But in the case of the pilotage, the remote pilotage, where the pilot is not going to board the vessel, then you still have the pilot perform the traditional role of providing conduct for the safe passage in local waters. So that is the most that the pilot would do. And what is interesting here is, of course, to remember that the master is always the person who has ultimate responsibility for the vessel. So if it turns out, for instance, that there is incompetent advice from the pilot, which sometimes occurs, the master has full authority to set aside the pilot's instructions.
So we've been talking previously, or as I follow the IMO stuff, they're talking about remote control operators, but you're really talking here, the remote control operator is the master. They're taking over the vessel, and they might have two assistants because they're in 8-hour shifts or whatever, but basically they are in charge. They're in effect the master now. And they may get advice from VTS or from other passing ships, whatever, but ultimately they're in control of the vessel. Is that correct?
That's a very interesting point too. We have to see how these shore-based operations are going to evolve. Will it be one person responsible for the ship? Will it be one person responsible for a fleet of ships? Or will it be more than one person responsible for the same ship to carry out the shifts that are required, as Yuri suggested earlier? We haven't seen those addressed yet.
Okay, got a question for Ash maybe. What if a state is not a party to UNCLOS and does not allow innocent passage of Mast through its territorial waters?
Well, the right of innocent passage is a customary law right. And so not being a party to the LOS convention, that doesn't change anything with regard to the coastal states' rights and duties with regard to ships in innocent passage.
Right. And if the Americans would do a phone op if it's a U.S. mast, but it's a different issue. I have a question here. I think we'd all agree. Would it make sense to proceed incrementally with Mast? For example, we'd start regulating vessels that are not unmanned or fully autonomous, and then develop standard practice that will make it easier for UNCLOS to eventually accommodate fully autonomous vessels without needing to be amended. Well, if UNCLOS is incorporating the IMO conventions that are gradually amended, then that would be correct. But I guess the question is whether there's things that in UNCLOS that are not quite, can't quite be fully dealt with by IMO conventions. That's one of the underlying issues. Could you discuss the position where a mast caused a collision due to it being controlled by an unknown entity as a result of a cyber attack?
This is a very, very tricky issue. And the whole question of cyber threats to shipping is, of course, a very real threat, and it's general. It applies to any kind of shipping, and we have seen very many such incidents already, and there are probably going to be more of them. But of course, the mass dimension adds one level to the problem, and that is that there might not be anybody on board who can take control of the situation. So I think this is something that also needs to be addressed preferably very quickly and at global level. Right now we have very generic requirements on cyber security. We have since the beginning of this year a requirement that it should be part of the ISM code consideration, but really sort of more operational requirement on what standards ship owners should maintain would, I think, be very useful, regardless of whether we are talking about mass or not.
Okay, I see our time is actually, we're over time already. It's an hour and it's over 90 minutes. Is that correct, Dawoon?
Yes, yes, Prof.
Okay, so I think we should perhaps, if anybody wants to make any closing comments, otherwise we have another, we're going to give you a commercial for a follow-up session that's coming, in which we will change the focus slightly. That will be announced. We're looking at it next time primarily from the perspective of flag states, although we got into flag states a lot tonight as well.
Jerry, could you please share the screen, please?
But and while she's sharing the screen, let me thank our panelists for their time and their enthusiasm and their comments. I think we're at a very high level of discussion in many respects. And I hope that the audience enjoyed the presentation and the conversation. We're going to have a second session on this issue on the 15th of November. Same time, 8 p.m. Singapore time, the nexus between UNCLOS and the IMO conventions. And we're going to delve in particular on the issue with respect to Article 94 and the other provisions in the UNCLOS provisions, which were intended to incorporate by reference the IMO conventions, whether they be general rules on generally accepted international rules, standards, procedures, and practices with respect to safety or with respect to pollution, etc. And to what extent the issue of autonomous vessels may give rise to some problems under those provisions. So it's a follow-up, it's a continuation of what we did today. We're very happy. We'll do a report on this. We'll try to get a summary report on our website. But we hope that audience was able to absorb the issues. If it would help for us to put some of the provisions up in advance for perhaps audience that wanted to do a little more reading beforehand, maybe we could put some of the relevant provisions of UNCLOS, make them available for those that are interested prior to the session. And I'd like again to thank our experts. and hope to see you again, or I know I'll see our experts again on the 15th of November. So with that, we'd thank everybody and for attending, and look forward to seeing you again.